This video discusses what I am sure is everyone's favorite topic. Section 5A of the Federal Trade Commission Act and why it is important to information governance. To make a long story short, Section 5A of the FTC Act prohibits businesses from engaging in unfair and deceptive trade practices in or affecting commerce. This prohibition applies to all persons engaged in commerce, including banks. Based on this very broad language, the FTC has created a regulatory framework in which many types of activities constitute unfair and deceptive practices.
Over the past 2 decades, in particular, the FTC has used this authority extensively to hold businesses to fair and transparent privacy and security standards. The example that we are going to be discussing today involves a Utah-based company known as InfoTrax Systems and an FTC consent order from 2019 which illustrates the interplay between the FTC's power to sanction unfair and deceptive trade practices, generally, and the specific power to sanction practices that relate to a breach of privacy and security. Let's go. The InfoTrax case arose out of a fairly egregious set of circumstances. For nearly 2 years, InfoTrax, a provider of direct sales solutions, was unaware that its IT systems were being repeatedly hacked. InfoTrax only discovered the breaches after a data archive file created by the cybercriminal maxed out the server's storage capacity, prompting an alert. In all, the company's server and client websites, which were maintained by InfoTrax, were hacked more than 20 times between May 2014 and March 2016. In March 2016 alone, the hackers stole the personal data of 1 million people.
Following an investigation, the FTC found that InfoTrax failed to use reasonable, low-cost, and readily available security protections to safeguard the personal information it maintained on behalf of its clients. Examples of this misconduct included storing consumers' personal information in plain text on its network including full names, physical addresses, and telephone numbers but also their social security numbers, payment card information, including account numbers, card verification values, and expiration dates, bank account numbers, and login credentials. The FTC also found that InfoTrax failed to implement measures to detect anomalous activity in cybersecurity events, to adequately segment its network to ensure that one client could not access another client's data on the network, to properly assess cybersecurity risks by performing code reviews and network penetration testing, to detect malicious file uploads by implementing protections such as input validation and to limit the locations to which third parties could upload unknown files on the company's network.
The FTC further specifically listed InfoTrax's failure to have a systematic process for inventorying and deleting consumers' personal information stored on InfoTrax's network that is no longer necessary, as one of the unreasonable security practices that led to multiple and repeated security breaches. As part of its decision and order settling the case, the FTC required InfoTrax, among other things, to implement a comprehensive information security program that is subject to third-party biennial assessments for the next 20 years.
There are 2 important lessons to be learned from InfoTrax's experiences. The most crucial one is that U.S. companies can be held liable for safekeeping personal information based on the general prohibition against unfair or deceptive acts or practices in or affecting commerce.
Second, companies must take measures to detect IT system intrusions and data breaches. Studies have shown that the longer it takes to identify and contain a data breach, the more costly it will be for the company. Notably, from a record-keeping perspective, InfoTrax was required to create certain records for 20 years after the issuance date of the order, and to retain each such record for 5 years, unless otherwise specified. These records included accounting records, personnel records, copies of consumer complaints related to the subject matter of the order and records of compliance assessments and subpoenas. This corrective measure aimed to address the first core element of the claim, namely the company's demonstrated lack of care with respect to maintaining the security of personal information.
Now, for the part that we have all been waiting for, how can we help? The experienced team of information governance professionals at Knowledge Preservation provides a wide range of information governance consultancy services. These services range from the creation, review and vetting to the formulation of various information governance policies to implementation services and client training programs.
Contact us today to discuss how we can help you create defensible, cost-effective and relevant information governance solutions.